So can we afford it or not? Well, the full text of that interview you could see on Thursday by 4:30 here at Channels TV. But Mr. Liberals Oshoman joins us next to get his perspective on the development at the moment. It's the big talking point. Thank you for coming on this morning.
My pleasure always. And you guys are looking, let me use the word takeaway this morning.
Looks can be deceptive. What do you think we should do about this? The president has given his perspective of it in terms of his understanding and interpretation of what the law says. Yes, you can have them, but as it is, definitely he says there will be merging ministries. You won't have ministers who will run some ministries, and people think otherwise.
Chamberlain, I would not want to recite that section of the Constitution because it's been cited here over and over again, and the question should be, are we ready to move forward as a nation? If we are ready to move forward, is the government also ready to move us forward? If the government is ready to move us forward, are we ready to assist the government in moving us forward? If all of these answers are yes, I really don't see why we should hold on mechanically to sections of Constitution and say, the Constitution says this, the Constitution says that. Let me tell you, Section 188 before now, the interpretation of most lawyers, even in seminars, senior advocate, was that once a governor is impeached, the court had no powers to question it. But it took the wisdom of the Court of Appeal to say, no, you have subsection 1 to 9. You must comply with subsection 1 to 9 before you invoke subsection 10. Until you do that, the court had power to question it. And so it now became what the court says the law is. And everybody clapped, oh, beauty of democracy and all of that. In the same vein, we're at a crossroad here. Some of us are of the view that if the Constitution says you have the discretion to appoint ministers, you have the discretion to create ministries, but in creating ministries, you should have recourse to the states. Also, if we believe that these ministers appointed from this state are not representative of the states, they are ministers appointed for the purpose of spread, federal character. And that is why the Constitution says, look, in doing this. But if you have a discretion to create ministries and you look at your books, you look at the ministry, it is not possible for you to create 36 ministers. What do you do? Do you now create 36 ministers and declare some redundant? We'll be paying them. Because for me, as far as I'm concerned, when you are a minister of state, you are a redundant worker. Because in labor law, when there are less job among hands, the ones that are not working will be declared redundant. Why appoint a minister you will house, you will pay for his aids, you will pay for his travel expenses, you will pay for his cars, fuel the cars, movement, and all of that, and at the end of the day, he's not working.
What about those who argue that the same principle, when you have a president, you have a vice? Is the vice redundant?
That is why the Constitution says that the president can delegate portfolios to the vice president.
But we've seen ministries and ministers too.
But in this
when
case,
the substantive minister is not there, the minister of state steps in. And in some cases, when the minister goes out for political campaigns or maybe seek political office, the minister of state substantively steps in and takes that position.
When you resign, another minister should be appointed. You don't appoint you don't appoint a Liberos and say, look, be watching Chamberlain. Anytime Chamberlain steps out, you will take Chamberlain's position. No, okay, your overhead, you will unnecessarily increase your overhead.
Okay, but the problem, what I think the president is trying to say, which many people think is clear, is that I'm willing to obey the law, what it says in appointing them, but
by provision of that section,
the economics of it is where he finds a challenge.
By the provisions of that section, the president must not appoint 36 ministers. That is what I'm telling you.
Oh,
he must not.
Okay, you disagree with the lawyers.
I disagree with Mebu and
in fact, they say it should be 37.
No,
not 36.
No, look, Lucien, we hold on. Like I said, we hold on mechanically to these sections of this Constitution, and the Supreme Court had consistently maintained in interpreting the Constitution, it should be interpreted to meet the demands the intendment of the drafters of the constitution, and then also to take care of the situation. What situation?
Give us your interpretation. Why did you say it's not 36?
That's what I'm telling you, that Section 1 gives the president the wide powers. You should appoint ministers, create ministries. There is nowhere in this law where ministries are created. That is the exclusive preserve of the president. And the president has said, look, I don't have 36 or 37 ministries to create. It is only when you create ministries that you put ministers.
No.
Isn't that
the cart before the horse?
Your colleague disagreed. I mean, he said that, that we've always had
ministers for states.
42, as it were, 42 ministers. We've never, and we don't have 42 ministries.
No. That's why we are complaining now that the overhead had always been too much.
It's the overhead. I don't know if we're getting this right. Perhaps, maybe finally we'll have to ask the president where exactly, he's concerned about the overhead. Is the overhead with the ministers or is the overhead with the ministries?
Both the ministers, both the ministry. My colleague talked about Minister for Special Duties, Ministry for Special Duties. That's one. I don't see the difference between Ministry for Communication and Ministry for Information.
So they're going to be merging ministries from what we can gather. So, ministries will be merged.
Yes.
But then the Constitution stipulates 36 ministers, which the president has appointed.
In as far as I'm concerned, that section of the Constitution, that's why the law is a very beautiful profession. If you bring 5 lawyers here, you might have 2 this way, 3 that way. That in the same vein.
Or 5 different opinions.
Yes, or 5 different opinions. That is why even in judges,
exactly.
That is why even amongst judges of 5, you have dissenting opinion. And so what we should be doing now, like I said, it is what the courts say the law is, that the law is. It is not what you sit down here to say the law is. What I expect at this stage, if let's say I'm from Edo State and there's no minister appointed from my state, I will go to court and say, look, court, please, I need you to interpret this section. Must the president appoint ministers from my state? And if not, why? If yes, why has a minister not been appointed from my state? That will give the court an opportunity to look at this matter and make a pronouncement on it. But as it stands now, even if I go to court...
Just a moment. Even in matters that look extremely clear...
No.
I mean, that look as clear as day.
Not at all.
For instance, that if
he
will appoint ministers, he must appoint one from at least each state. I mean, some will say, how simple can you get again?
You need to look at the intendment of that section. Section 14, Section 147, Section 14, Section 148. You need to look at all of this together and then also look at the approach of the Supreme Court in interpreting laws. When you cannot take that subsection 3 in isolation and say it is clear. That's a mechanical approach to this issue.
Okay, Liberals, we'll get your point. But where we think the president is predicating all of this is that I don't think the appointment of the ministers is that much of a contention from the president's comments. Where the challenge arises is, where will they be? What is that's the economics of it now, not the legality of it.
No.
Because
let me tell you, that before now, it was easier for people to say, look, you must, even some are arguing that once you appoint minister, like Ibu said, you must give them ministries. So that's another problem. To avoid all of these problems, if you have 20 ministries, appoint 20 ministers. Let's go to courts. The Supreme Court will make a pronouncement. You don't need a constitutional amendment.
What
Do you know why?
What you're saying is that this can be tested.
Yes.
And
you don't need, because
it should be tested.
Amending it is a longer route. You might spend the next 4 years trying to amend that section. But the easiest route to this, why don't we take the quickest approach the court? And instead of doing it for 4 years, you do it in 4 months.
So what is the intendment of the drafters?
The intendment of the drafters is, one, have, federal character and have spread. It is not that the president must mechanically hold on to, in a situation where you don't have for 36 ministries, you must begin to create ministries.
Let
in
me
a
bring this
situation,
in,
if
then.
you have 50 states, you must begin to create 50 ministries.
If you have 15 ministries, and you say, I can only appoint 15 ministers because I have 15 ministries, how does that address the intendment of the God? For spread, which you talked about.
Yes, the way you are, because Section 14 already says that you must also comply with federal character. And so it's not compulsory that you must have a minister from Edo State, minister from Bayelsa, minister. It's a region. It's a geographical zone. So if you have 2 ministers from that zone, that's enough, because the ministers are not even representative of their states. They are not representing the states.
The law used the word states, not zones.
That's what I'm saying. The law used, in the event that you have 36 ministries, all of them the spread must go round. It must not be from one particular state. But in the event that you cannot create 36 ministries, because the creation of the ministry is your prerogative. In the event that you cannot do that, once you do, you are not violating the Constitution. Let those that believes otherwise approach the court. Or you can even take this matter, if you have an attorney general, you take this, it's a matter of constitutional interpretation, before the Supreme Court for a pronouncement. It's a very easy way. Look at Saraki's case before the Code of Conduct. He says the panel was supposed to be a panel of 3, but that 2 are sitting, and that there is nowhere in the law where it talks about quorum. And the Court of Appeal have made a pronouncement that 2 can form a quorum. And so that had laid that one to rest. You didn't need to now amend the Constitution to bring that one in to address that issue. And now he's gone to Supreme Court. At the Supreme Court, we will also hear a pronouncement. And once the Supreme Court makes a pronouncement on it, it becomes the law. Look at the case of Atiku, when Obasanjo threw anything at him, on the proviso that once you have been indicted by a panel of inquiry, you cannot stand for election. And the court said, no, that panel of inquiry, that judgment, that indictment must be adopted by a court of competent jurisdiction. Until that, you cannot disqualify the person. How about the case of INEC? When INEC, by virtue of this same rule, this same constitution, INEC says, look, we have powers to register and deregister political parties. Then if I may approach the court and say, no, you don't have that powers. And the court interpreting that section says, no, the section does not, that wide powers that you assume that you have, it's not well spelled out here. And so that became the position of the law. That is how a society develops. That is how you develop your legal jurisprudence. And not everything will say go back to National Assembly for an amendment.